Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, we're going to talk about something that we have routinely talked about post-Bruen, and that is this post-Bruen enlightenment, where we're going back and we're doing some significant soul searching on a lot of federal legislation and determining, hey, is this stuff really constitutional to begin with? And one of the areas that is really, really ripe for litigation right now, and we've talked about it quite a bit, is the inability of people convicted for nonviolent felonies way back in the day to ever restore their Second Amendment rights and be able to exercise their right of self-preservation. Now, we've talked about a couple of really important cases, the most important one being Range versus Attorney General of the United States, but there may be a case out there that is going to be far more helpful for people who fall into this category. It may absolutely turn out to be the biggest case in this entire argument that's going on. So today, let's spend a few minutes and let's get you educated and let's talk about the most important case for nonviolent felons to get their Second Amendment rights back. You watch the news, you read the headlines, and you know it for yourself. Your community is less safe than it was just a few years ago. So you decided to purchase your first firearm. But like everything else in your life, you wanted to do this lawfully and responsibly. So you trained and trained and trained. You learned the laws of self-defense and all the tactics necessary to protect yourself and your family. To this day, you continue to train, and you now live by the motto that it's better to have it and not need it than need it and not have it. You are prepared for anything, or so you thought. Who are you going to call when it all hits the fan? Who's going to defend you for defending them? Who's going to stand in your corner when you realize that proof beyond a reasonable doubt means one thing in a high school civics class and something altogether different in the real world? Introducing Right to Bear, self-defense coverage that protects you so that you can protect them. With an attorney-answered hotline, you will always get a confidential conversation with your state's attorney. There are no cap limits for either criminal or civil defense. All forms of self-defense are covered, so from a fist to a firearm, you are protected. And you will have some of the nation's most passionate 2A attorneys defending you. And the peace of mind that you will have knowing that Right to Bear is in your corner, well, that's priceless. Listen, I've been in this industry long enough to know two things with absolute certainty. Good lawyers aren't cheap, and cheap lawyers aren't good. So visit my friends today at protectwithbear.com, and if you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, here's what we're talking about today. We are talking about the case of Vincent v. Garland. We have not talked about the case of Vincent v. Garland. It comes out of the 10th Circuit and is now being petitioned to the United States Supreme Court by the plaintiff for review. So we all know how Miss Vincent did at the 10th Circuit. Now, what's being challenged here is 18 U.S.C. section 922 G1, the exact same statute which is being challenged in the Range case. That is a statute that says if you have ever been convicted of a crime for which you could have been sentenced to more than a year in jail, not that you were, but that you could have been sentenced to more than a year in jail, you lose your Second Amendment rights, and in many instances, it is absolutely impossible, oftentimes on the federal level, to ever restore those rights. The actual statute that we're talking about specifically reads, "It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to ship or transport in interstate or foreign commerce or possess in or affecting commerce any firearm or ammunition or to retrieve any firearm or ammunition which has been shipped or transported in interstate or foreign commerce." Now, the plaintiff here frames the issue to the United States Supreme Court as follows. This case presents an important question of constitutional law that is subject to a growing circuit split. Whether the Second Amendment allows the government to permanently disarm a U.S. citizen who has a years-old, non-violent felony conviction. This court's review is necessary as the Solicitor General agrees to resolve the circuit split and provide much-needed guidance to the lower courts. And that circuit split is actually what makes this case highly likely that it could be accepted for review, because as we know, there are some circuits that have said, hey, 18 U.S.C. 922 G1 is totally fine, no problem at all. And then there are other circuits who said, hey, wait a second. We don't have a historical tradition here of disarming everybody. Now, we might have a historical tradition for disarming those that we believe to be dangerous. But here's the thing about the plaintiff in this case, Miss Vincent. Miss Vincent was convicted about 30 years ago for trying to pass a bad check. Now, I'm not condoning her activity, okay? And there could be a lot of explanations for why it happened. It could have even been accidental in nature, but that's ultimately what she went down on. Now, since that time, and the Solicitor General for the United States agrees with this individual has absolutely turned her life around. She's not only gone out and got herself a college degree, she went out and got herself a postgraduate degree. She is a law-abiding, very successful, contributing member of society by all accounts, including what the United States government argues here. Now, this case had been kicking around for a little while, and the 10th Circuit had kind of put it on hold, waiting for the Bruen decision to come down. One would think that Bruen decision would have got the 10th Circuit to the right place, but hey, here we are talking about this case, so you know what happened. As the plaintiffs put it, on appeal, the 10th Circuit stayed proceedings until this court decided Bruen. Bruen held that to survive Second Amendment scrutiny, the government must affirmatively prove that a firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Even so, the 10th Circuit ultimately affirmed dismissal of Miss Vincent's suit without applying Bruen's historical analysis. Now, this unwillingness or inability by the 10th Circuit to do any type of proper historical analysis has actually left this opinion really vulnerable, as the plaintiffs point out. As a result, the 10th Circuit has never examined the historical basis or lack thereof for disarming people like Miss Vincent, who never posed a physical danger to others. Nor has it required the government to affirmatively prove that Section 922 G1 is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. And the 10th Circuit's rule is categorical: no as-applied challenge to 922 G1 is viable. And since this activity is obviously covered by the plain text of the Second Amendment, the government must now establish that there is a historical precedent that would allow us as a society to accept these types of limitations moving forward. As the plaintiffs wisely point out, under Bruen's historical test, the decision below cannot stand. Section 922 G1 violates the Second Amendment as applied to Miss Vincent because our historical tradition of firearms regulation does not permit the federal government to permanently disarm someone based solely on the fact of a prior nonviolent criminal conviction. That is true, especially where no evidence suggests that the person poses or has ever posed a threat to anyone else. Now, obviously, what the government is arguing is, hey, listen, Miss Vincent's a convicted felon, and therefore she is not part of the people as contemplated in the United States Constitution. The plaintiffs deal with that this way. Other constitutional provisions reference the people, including the First and Fourth Amendments. Unless the meaning of the phrase, the people, varies from provision to provision, and the Supreme Court in Heller suggested it does not, to conclude that felons are not among the people for Second Amendment purposes would exclude them from those other rights as well. There is no reason to adopt an inconsistent reading of the people. And that is an excellent point, and one that also everyone should consider when we're talking about should illegal aliens be allowed to possess firearms, but I digress. Now, the plaintiffs also point out the government cannot show a historical tradition of permanently disarming nonviolent offenders. The government cannot show a relevant founding era analog to either the why or the how of Section 922 G1. As to the why, no evidence has emerged of any significant founding era firearms restrictions on citizens like Miss Vincent, who committed only nonviolent offenses and posed no physical threat to others. And then, of course, there's the how test as well, which the plaintiffs point out. As to the how, no founding era evidence has emerged of class-wide lifetime bans on firearms possession merely because of a conviction status. In fact, total bans on felon possession existed nowhere until at least the turn of the 20th century. And what the plaintiffs point out, and this is incredibly true, and this is an issue that absolutely positively needs to be resolved, and it needs to be resolved right now. As they put in their memorandum, The court should grant the petition because this question is vitally important. A circuit split on the validity of a federal statute alone typically warrants review. And that is even more true when the question presented concerns the scope of a core constitutional right. The court should decide whether peaceful American citizens who have paid their debt to society may be permanently deprived of the right of self-defense despite the Second Amendment's guarantee. Without the court's intervention, Section 922G1 will deter countless peaceful Americans from possessing firearms for self-defense with no real benefit to public safety. Now, I said earlier that this case may actually be far better situated for the United States to accept review of this issue than the Range case. Why is that? Because one of the things that's being challenged in the Range case is whether or not Mr. Range even has standing as an Article 3 standing. I'm not going to geek out on that, otherwise we'll end up with a 20-minute video here. But there is that challenge that would also have to be resolved by the United States Supreme Court. However, in the Vincent case that we're talking about today, there is no question about Article 3 standing here. The Solicitor General has never tried to argue that she does not have standing. So this case, for lack of a better term, is a much cleaner, more sterile case that could get before the United States Supreme Court. For one thing, one of the Third Circuit judges argued that Mr. Range had failed to establish Article 3 standing, an issue this court would have an independent obligation to address before reaching the merits. And so it is that exact reason that this case, Vincent v. Garland, may actually be the best vehicle by which we can finally determine once and for all whether or not non-violent felons should have a road to restoration of their Second Amendment rights. We have a historical tradition in this country of disarming dangerous individuals. We have talked about that over and over and over. But you see, Miss Vincent here, even at the time that she was under indictment, was never considered to be a dangerous individual, has never been considered a dangerous individual, to the best of anyone's knowledge, has never engaged in any kind of activity which endangers others. This is a case that is ripe for review. We're going to carefully watch it because, candidly, the Supreme Court does need to resolve this issue once and for all. The case, once again, is called Vincent v. Garland. We'll link it up down below so that you can geek out on the petition for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. And stay safe.